judges, they will have to sit down someday and decide how to get over this issue. These, as I highlighted today, are only the practical aspect of it. How it to be done is something which I have not been able to think of so far, because I think that even if no adjournments were granted, all the judges came in time, all of them worked very hard, pendency will stick with them. It can never be. In the present circumstances, it's difficult to get rid of it. Now, the other aspect of the matter which I wanted to say a few things was the public participation in framing of laws. Now, in the broadest sense of the term, we have representatives in the parliament, in the legislatures, state legislatures. They represent the people. They make the laws. To that extent, our views are perhaps reflected in the laws as they are enacted. But what is being said today is that apart from that also, when a law is sought to be enacted, people should be heard in the sense that their views, their opinions should also find place in the law. We know that the committees of the parliament, they do hear people, important people, social activists, others interested with that branch of law before a law is finalized. But then today the thinking is that something more than that. I don't know what is something more than that, but let me tell you the pitfalls. You see, there was a time when we all started talking about the law being kind to certain sections. And the first section, which was to benefit, were the juveniles. So we had to do justice with juveniles. That act came into force. Lenient towards the juveniles. They were not treated as criminals. Even if they committed an offense, the law thought that they can be reformed. Therefore, why send them to jail? Why not reform them? That was the public demand. That's how the law was framed. Now, I want to say one thing at the threshold. I'll take you to other branches also. When the parliament acts as a lawmaking body, my view is that it should act in a normal way in normal times. Whenever a law is made or framed or enacted under some pressure, the law that is the resultant is an imbalanced law. Because you are influenced by what has happened recently, and you make a law to protect that section which has been adversely affected by what has happened. And in doing so, you forget the other aspect of the picture. That's where we commit mistakes. Let me illustrate this. Now, so Juvenile Justice Act, you protected the juvenile. The international thinking was that they should be reformed. We also fell in line. Good. Then came, you must frame some laws for protection of women. Very valuable thing to do, because a lot of cases came to light where there were atrocities committed on women, daughters-in-law, things like that. And then a series of amendments took place in the Indian Penal Code to give protection to the female, which was a very laudable objective. But then what happened? That law was misused to such an extent that today we are thinking of doing something with that law also. Because that was done at a time when there was a lot of pressure on the parliament. No, this law has to be amended. Then there was a time when they said, you can't order death sentence. That's not permissible. Human being can't, only God can take away the life given to a human being. So there was a big move saying there should be no death sentence. In our country, that was not accepted. And all that the Supreme Court said was, in the rarest of rare cases, this punishment can be imposed. not in ordinary cases. So ordinary case of murders, life sentence or whatever. Now, we recently witnessed a very dastardly event that took place in Bombay. And then the same people who were talking for the juvenile, who were speaking against death sentence, are today saying, no, don't exempt the juvenile. He has done an act which is unpardonable. He should also be punished like any other person, and he should be sentenced to death. That, I suppose, all of you remember these things came out in the press. So, how do you find out what public opinion is? If you go by individual cases. You can't, if you talk to ordinary man in the street, everyone has his own views. I don't think the lawmaker can take all those views into account. It has to be through some organized channel or some activist bodies, things like that. And look, these laws have been framed. All of them have been framed under some pressure. And all of them, in their implementation, have disclosed that you have looked at only one side of the picture. You have not looked to the other side of the picture. That is because you are under pressure to legislate. Therefore, my view is that the Parliament should legislate in normal times and in a normal mood, not under pressures. And whenever a law is produced, a law is enacted, which is on account of any sort of pressure from any group or person or public, that law will be found to be an imbalanced law and will require further changes in future. Now see where the law has not been framed, where it should have been framed. Long ago, Supreme Court gave a judgment, Vishakha's case, well-known case, where certain protection were given to women in their workplaces and other things also, court proceedings. Argument was, where is the law? The Supreme Court said, all right, there may be no law. We are laying down the guidelines. Until the Parliament formulates the law, these guidelines will operate. They are operating till today. The Parliament has not made a law. Therefore, Parliament is supreme, so far as the legislative field is concerned. Supreme Court sometimes advises them that it is desirable to frame laws, but it can't command the Parliament to make laws. That's a function of the Parliament. And the Parliament decides for itself when to frame the law and what law to be framed. But certainly, the people of this country are the ultimate sovereigns, and their voice has to be heard. How the Parliament will do it is something which is for the Parliament to decide, and I'm sure they'll do it in a very fair manner. Now, these are my opening observations. I'm sure you'll have a very fruitful discussion in the following sessions. Thank you.
Thank you. Thank you, Justice Singh, for an excellent expose of the perception of judges in regard to their difficulties, problems, and their excellent performance. I would not like to join issues with him because it is not a seminar on judicial reforms, but I am tempted to say that there is another side of this story. May I now request Honorable Minister Dr. Purandeshwari to deliver her inaugural keynote address.
Honorable Justice Mr. B.K. Singh, Dr. Kashyap, Shri Kaviraj Singh, delegates, participants, invitees, ladies and gentlemen. Let me begin by saying it is indeed a great honor and privilege for me to be here amongst all of you this morning, even as INBA celebrates the Law Day. Well, even as I was sitting and listening to Mr. Singh on the deep insights that he gave us on the legal aspects and the lawyers' difficulties and challenges and so on, and even as I was looking at the audience, seeing a lot of legal experts sit there, I was wondering what was I doing here? Probably a fish out of the water, just a policymaker who's sharing the stage with the legal experts. This just brought to my mind an experience of mine when I had first entered the parliament in 2004. This is slightly on the lighter vein. I was kind of lost initially, not knowing how do I intervene in the parliament proceedings, how do I make my interventions, how do I raise questions, and so on, which was when I asked a senior colleague of mine as to whether he could guide me when it comes to all of this. He looked at me, gave me a very complacent smile and said, "Purandeshri, this is the easiest thing that you can do. The minute you think you want to make an intervention in the parliament," he said, "raise your hand." Went on further to say, "Don't bring your hand down until the speaker sees you, despite it going numb with pain." And then he said the speaker would definitely catch you, and then he would call your name, which is when you need to rise to make your interventions. And the minute you say, "Thank you, sir," you would hear a bell ring, just to indicate that the 2 minutes allotted to you is over and you need to sit down. But he went on to say, "Don't sit down, because as a parliamentarian, it is your right to speak. And as a speaker, it is his duty to ring the bell. So ignore it and continue speaking." But he went on, what he added later on was quite interesting, because he said, "Purandeshri, you can speak for n number of hours and say nothing," which is something that I need to decipher even to this day, how you could speak for long, long hours and yet say nothing. This is just on the lighter vein. And that is an incident that just crossed my mind as I was sitting here on the dais. But let me say, I would like to take the opportunity to congratulate INBA for actually bringing the legal fraternity, industry, policymakers onto one dais, where issues and challenges could actually be debated, deliberated, discussed, and probably the resolution that comes out of the conference could actually be a beacon of light for policymakers even as they're making their policies. The topic that was suggested to me was liberalization of FDI in India. But even before I start speaking about the liberalization of FDI in India, probably we need to speak of the incredible economic journey of a credible economy called India. Well, the term emerging markets, as we all know, was coined almost 3-4 decades ago, but came largely to be used probably in the 1900s. And this word was actually coined by the World Bank at that point of a time. And from a handful of economies, say in East and Southeast Asia, the word was expanded to include economies in the Middle East, West and East Europe, Latin America, and even Africa as well. And today, among the emerging markets, India is considered to be a sleeping giant who has just woken up from her sleep, next only to China. These emerging markets, as we all know, do play a very important role when it comes to the progress and the growth of the global GDP. What happens in these emerging markets have a great impact on the entire global GDP, both in terms of the demographics as well as in terms of the economics. When we look at the demographics, these are the markets that actually house almost half the world population. You have a large consumer base here, yearning for better living opportunities, better living conditions, and therefore they offer markets to probably the entire world. And India herself, with a 1.2 billion population and an ever-increasing middle class of anywhere around 400 million, is indeed a large market which the entire world is today focusing on. And her confident stride forward is being watched by the entire world. Even as we talk of India, a giant that has woken from her sleep, we also need to take into account the two large global slowdowns that we were actually faced with in the recent past. The first one being in 2008, which had its epicenter in the United States of America. People did strongly believe that India was going to crumble, which was then, it would be incorrect if I were to say that we were completely insulated from the global slowdown, but definitely we did feel the ripple effect of the global slowdown. When we compare ourselves to China, which was probably growing at around 13% at that point of a time, slipped down to 9%. But India, which was growing at around 8%, slipped to 6%, which is 2 percentage point drop. The reason for us not being as badly affected as the other economies of the world were affected is thanks to the conservative banking system that we have in our country, which probably the Western countries and the developed economies did want to, it wouldn't be right to say ridiculed, but rather didn't take it seriously, but called us very, very conservative. But it was that conservative banking system that probably saved us from actually crumbling down under the pressure of the global recession or slowdown. Along with that, we do have a large consumer-driven economy in our country, and everything, or largely what was produced by us, was actually consumed by our own sections of people in our country. And these were the two main reasons which rather protected us from crumbling very badly under the weight of the global slowdown in 2008. And then came the global slowdown in 2010, or rather the Eurozone crisis, as it was called. We are yet to come out of the effect of the Eurozone crisis. And it is here that we are today looking at non-conventional markets, even as we strengthen our presence in the conventional markets like the United States and the UK themselves. This is why we have been looking at Latin America and more particularly at Africa, because we believe that
And we found that if in America, for a certain population, you had 167 judges. I mean, my figures may not be accurate, I'm just illustrating. Then people said, no, you can't compare yourself with America. That's a different type of a state, a different stage of progress. For the same population, you had about 60 odd judges in developing countries, in Africa and other places. As long as that, in India, we had 10. So if you increase the number of judges, strength of judges in this country 6 times, then you will reach a stage which has been already reached by developing countries in other continents. Can you do it? Can you multiply your judges 6 times? It's not merely judges, the infrastructure. Can you get that infrastructure? Can you get that assistance for the judges so that they can discharge their duties with efficiency? Can you get good stenographers? Will the lawyers not object? To that, someone suggested, let's have 2 shifts, morning shift and evening shift. Now that has its own complications, because all that you save there is on the building, rent of the building or the cost of the building. You don't save anything else. The rest of the expenses are there. Which lawyer would agree to work from, say, 9 to 5 and then again from 6 to 10? So those problems are there. And I think we'll have to do a little serious thinking on how to achieve this. And therefore, it becomes sort of natural consequence that the cases are not being disposed of as fast as we would like them to be disposed of. I mean, it's like saying this, that if a person can deal with 100 cases in a month and you give him 5,000 cases to dispose of, 4,900 cases will remain pending. Fortunately, that is not the position in our country, because I think in fairness, people should be told not merely how many cases are pending as backlog cases, But how many matters are disposed of each year? There also we saw the figures. And again, I'm not giving you the exact figures, I'm just trying to illustrate that if in this country 1 crore and 50 lakhs cases were filed in a particular year, 1 crore and 45 lakhs were disposed of. It's only that small percentage which goes on adding to the backlog. So the backlog becomes impressive to look at. But you are not giving due credit to the judges, who is, in spite of all the adverse circumstances in which they are working, are not complimented for what they have achieved. They are condemned for the backlog, which is created not by them, but by people in the past. If you can say it is caused by anything, it is caused by the circumstances that exist, can't be helped. I am not trying to be critical about I don't want to be critical about the performance of judges in this country. They have done quite well. The adverse circumstances in which they work is also something which has to be experienced. I didn't experience it in Delhi, and you can't experience it in Delhi. Go to the small villages, small towns where these courts function, and look at the condition in which these judges function. Look at the facilities which are made available to them. And then you will find out that they are not entirely to blame for the delays. Take, for instance, a case where a judge wants to dictate a judgment. He has a stenographer whom he finds to be so incompetent that he would rather write it by hand than to dictate something to him. Because correcting a draft which you have prepared is more difficult than writing it afresh. Look at the manner in which the records are kept. Look at the infrastructure provided to the lower courts. It is pitiable. I didn't see it in Delhi when I was practicing here. But when I was a judge of the Patna High Court, and I had to tour these district towns also and the subdivisions to see how the courts function there, then I realized the plight of these judicial officers. They do their best, and yet they are condemned for not doing enough. I'll just illustrate this by one example. I had been to a district which was known as one of the hottest districts in India. And I was shown a courtroom which looked more like a garage, with no windows, no fans. It was dark. So I said, how does the judge function here? So that judge who was there, lower judiciary, magistrate, he tells me, he says, my lord, we manage to function. We get a lamp and we can read. I said, what about the lawyers? I said, they also make their own arrangements. I said, but why can't you have 2 windows and a fan? So he said, yes, if they could do that, it will be very kind of them. So the engineer was there. I asked him, why don't you open 2 windows? Let there be some light. So he said, sir, that can be done. I'll take the sanction, this, that, and the other, the usual story. And I said, then you can have the fans and lights also fitted. So the judge tells me, my lord, your lordship can forget that fan and light part. Windows will be enough. We'll get fresh breeze and we'll get light. I said, why can't you have fans and lights? He said, sir, there is no electricity. So that's the type of problems that they're faced with. And who is bothered about them? No one. Now we, as inspecting judges or administrative judges, would go to these district courts, call the executive engineer or the district officers, shout at them, arm twisting, some little arm twisting, get it done. It used to be get done. Delhi, you get a different picture. Bombay, you'll get a different picture. But the real courts are not in Bombay and Delhi and Calcutta and Madras. They are the courts in the remote parts of villages. Look at the judicial officers' predicaments. That's the only department where judges are transferred every 3 years. Every 3 years they are transferred. Religiously. It doesn't happen in other government departments. It happens in the judiciary. Because the tenure is 3 years. Every 3 years, they have to shift their family, their children. They have to be educated. They have to find schools, get them admitted. It does affect their family life. Seriously, it affects their family life. Sometimes you go to a big city, sometimes you go to a small city. There is no arrangement, no machinery, which at least assures that their children are properly educated. They are posted at stations where there is no doctor, If you want medical aid, you'll have to go to the nearest city somewhere where you may find a reasonable hospital for treatment. Despite all this, they still function. We had thought of computerizing some district courts. Most of them are computerized. Problem was there was no electricity or power failures. Or if they had to get generators went out of order, something went wrong with it, you can't repair it. So that's one aspect of it. Look at the second criticism. We keep on hearing a lot of things about the integrity of judges. Earlier it was confined to the lower courts. Now it has traveled up. I can tell you one thing, that most of what you hear is false. When I say most, more than 90% is false. Because those who give the judiciary a bad name are outside the institution. They spread a rumor that this can be done, that can be done. And they do whatever they want to do. The poor judge knows nothing about it. And I said one day openly in court, sitting in the Supreme Court, I said, look, don't blame the judge. A judge is sold 4 times a day without his knowledge. That happens. Therefore, all right, even if some part of it is true, that cannot be tolerated. That has to be checked. But then there are black sheep everywhere. In the judiciary, very strong, strict action is taken against judicial officers who are found to be corrupt or not maintaining the standards of a judge. The only thing is that we don't give it a lot of publicity. District judges, other judicial officers are dismissed from service, and the High Court has a role to play. That's a disciplinary authority. But if you give too much publicity to these facts, people will get an impression that everyone in the judiciary is corrupt. Therefore, it is not given that much publicity, but I can tell you that on reports, the High Courts do make a very detailed inquiry, and appropriate action is taken against judicial officers. Many of them are dismissed. But that perhaps ordinary man in the street may not know. That is a fact. And then when we are talking about pendency of cases, the bar has a role to play there also. Because when the judicial process works, the judiciary judges interact with the lawyers. That is the judicial process. This prayer for adjournments. Every time a case is about to be heard, the lawyer comes, or his client comes with some excuse for an adjournment. Now, let me tell you frankly, when a case is adjourned, it is not as if the judge is not doing anything else. He is still working. He will do the next case. So therefore, I will not attach much importance to that aspect of the matter. But what I must emphasize is that once you keep granting adjournments, mere asking lawyer, or without really scrutinizing the reason for the adjournment, there may be appropriate cases for adjournment. What happens is a certain casual attitude develops. A lawyer will tell his junior, say, I have not read this brief. You ask time, take time from the court. And the court grants time. Similarly, the judge also sitting at home, he finds a complicated matter. He says, why should I waste my midnight oil? Most likely it will get adjourned tomorrow, so forget it. Now, this casual approach is something which is most devastating. A court cannot afford to have a casual approach. And therefore, even at the cost of some displeasure to the bar, judges will have to be strict and curtail adjournments. Adjournments today, you see now I have retired from the court, I do arbitrations. They are also the same philosophy. Tomorrow, evidence is to be recorded. Today, the lawyer gave notice, I am going for my nephew's marriage. I can't come tomorrow, so adjourn the matter. That's what happens. So this attitude, this casual approach to your duties is something which is devastating, which has to be avoided. Now, when you talk about change, I'm reminded I started practicing in the year 1963. Those days, when we went to the Supreme Court, there were 11 judges. 11 judges. Initially, Supreme Court had 8 judges, 7 judges, 1 Chief Justice. And the corridors were quite empty. You could walk freely, no problem. In the courts, you would find judges coming dot in time, 10:30. There are some admission cases, used to be listed. There will be about 5, 6 on an average. They'll begin at 10:30. By 11 o'clock, admission cases would be over. 11 o'clock, regular hearing appeals would be heard. Go to the court today, you can't move in the corridors. Impossible to move in the corridors. You have to push each other. Those days we used to say, oh, the court has 11, 12 matters today for admission. It's a long list. It will take time, so it can go beyond 11 also. Today, a stage has been reached when on 2 days, 30 judges of the Supreme Court, now 30, do 65 admission cases on every Tuesday, Monday, and Friday. So you can imagine how the work has increased. Impossible. In the 60s, we couldn't imagine that the Supreme Court will ever have so much work to do. Imagine. Sometimes we must work out these statistics also. A judge deals with 65 cases on Monday for admission, 65 cases on Friday for admission. That makes it 130. Briefs, as you must have seen, are very big and thick. Let us assume that he does not need to read more than, say, 10 pages in one brief. So, 130 into 10 is 1,300. 1,300 pages per week, multiplied by 4. So you'll get the figure of the number of pages that the fastest judge is going through for only admission cases. I have not come to the hearing matters. These are admission cases. After all, he must know the brief before he can hear arguments. So, I mean, it can happen that a judge of the Supreme Court who is conscientious, who wants to do justice, has to read 10,000 pages per month, which only represents admission cases. The other 3 days, he has to read for his final hearing matters. And then he has to find time to dictate a judgment. So, no one seems to realize these facts. Everyone thinks, oh, his nice cushy chair is sitting in an air-conditioned chamber. That's not the true story. I can tell you that the laziest judge of the Supreme Court, laziest, works 14 hours a day. And the more illustrious, hardworking judges, some of them, I don't know whether they sleep at night. That is the position. Such is the burden. And we complain of pendency. Pendency is bound to happen unless you reduce the litigation. And it's an impossible task in this country because giving concessions is very easy, but taking back concessions is very difficult. You give a right today to a particular section of society, you will have this privilege. You can never take it back. Even if it was temporarily, it meant to be given temporarily. Now, the Constitution has developed in that direction, unfortunately I call it unfortunate from this point of view, otherwise it is welcome change, given more rights to the individuals. We have the fundamental rights. Now that jurisprudence has been developed, it has been extended. So today you have all sorts of litigations. You have public interest litigation. And then dependency is bound to rise. I don't know what way you can curtail this, but as I told you, we have to live with the realities. These situations are there. Our lawmakers